I am an estate planning attorney, and today we're going to talk about estate planning um, and how we address estate planning at our firm. Before we get started, I just want to make sure that people can see my screen. It says selecting and working with an estate planning attorney, and that you can hear me. So if someone can type in the chat box, that would be great, saying that I'm not talking to myself or just that you can hear me and see me. That would be great. Great. Everything's all good to go. Um, and if you do have questions throughout the today when we go through it, it's about, this presentation's about an hour to hour and a half, just depending on questions. I will go over key issues to consider when going through your estate planning. I'll go through common pitfalls that I see out there. I've been doing this for over 20 years. I'm not a personal injury attorney. I'm not a family law attorney. I do estate planning. And we also, our practice is about 60 to 70% devoted to estate planning, 30 to 40, just depending on the mix, on business planning. A lot of our clients happen to be business owners, and we're able to kind of integrate the planning for them on that side of things. And so I'll go through our process, how we work with clients, how we charge. This is an informational session, okay? This is not a sales seminar. I'm here to give you education and to provide you the information so that you can do your own due diligence. I think this sheet right here that's up is valuable. If I was looking to work with an estate planning attorney, these are the questions that I would be asking them, knowing what I know. Excuse me. And so everyone asked about price. I promise we'll talk about fees and fee options so that you're a good consumer on this. But you should be asking about 15 other questions, okay? And so my goal today is I'll check back in towards the end of the program and see, we'll go run through these questions to make sure that I've answered at least our answers. And then you can decide if that's a good fit for you, or if we're not a good fit, use that to go ahead and interview other attorneys and see. And so you get the best possible plan you can for you and your family. So I'll check back in with that one. So with that being said, I am going to get started. And so you'll find that that's me in a suit. So basically, InSight Law, we have a team of 10. We've got 4 attorneys, 6 support team members. We're adding people. We're growing. And our home base is in Ashburn, Virginia. I'm licensed personally in 5 jurisdictions, Virginia, Maryland, DC, West Virginia, California. I have a master's in estate planning. I belong to a national network of estate planning attorneys. I instruct there. And so I have clients in a lot of different jurisdictions because I'm able to co-counsel with other attorneys if people are looking to work with us. And I'm very blunt. You'll find I'm very blunt if we work together. Most estate plans just don't work, okay? And how would you know if your plan worked or not? Maybe when would you know? Might be a better question, right? After you're gone. And so my point today is let's think through those issues. People don't like to think about, disability and death, but if you ignore the issues, it really exacerbates really the impact on your family, and I'll show you that today. So what I like to start with, I'm a visual kind of learner, and so what I like to use is called the snapshot test. And the snapshot test goes like this. Visualize the time after you've passed away, and you're looking down from your cloud from above. All my clients look down; they don't look up, right? Beats the alternative. But if money's going where you thought it was going and people doing what you thought they'd be doing, then that's generally a plan that worked. Pretty basic. Money not going where you thought it'd be going, people not doing what you thought they'd be doing, things getting tied up in court, banks freezing assets, people fighting each other. That's not a plan that works in my mind. And so how does that look like to you? And you probably have a decent idea how that looks, or maybe not. The goal today is to really kind of focus that picture for you, because a lot of people don't know all their options when it comes to estate planning. I'm going to give you some key options to consider that people don't typically think about in our discussion today. So I always start with like typical traps that are out there in the world of estate planning. I see this all the time. And the one trap I find on the estate planning side is people focus on documents. What documents do I need? A will, a trust, a power of attorney, a medical directive, and childcare powers of attorneys, guardian, appointment of interim guardians. What documents do I need? And yeah, the documents are important, but that's just part of the story. And if you come into the relationship with the attorney just focusing on the documents, you may just get documents. And I'll tell you, to me, that's not really serving the best use for your family on the planning. My analogy is I use the analogy of Chip and Joanna. If you've ever seen the show, The Fixer Uppers, I love that show. They're a couple that go out and renovate people's houses. Joanna's the one that sits with the clients, and they trying to get their vision, their goal. How do you want the kitchen to look and feel, bathrooms, bedrooms, and the like? And Chip is the carpenter that comes in with the tools, right? And if you don't have to watch the show, if you've ever done any renovations or anything like that, you get it. And so the idea is, the analogy I have with estate planning is, when Chip or the carpenter is going ahead and renovating and implementing the plan, does anybody ask what tools he's using, right? And no. Right. It's more like, I want the kitchen counters to look and feel like this. I want the bathroom to look the end result, right? It's about results that we're looking for. Same thing with estate plans. Okay. The lawyer's documents are just our tools. Okay. The result is you want a plan that works. And a lot of our clients, we pull our clients on what their goals are, is that they want to, if they're married, make life easier for the spouse and the family. Make sure that we're protecting, if there is a catastrophic illness, that it's not a complete mess, to help, make sure that the assets are protected from creditors when it comes to after, passing away, or avoiding probate, minimizing taxes, those types of things. But the main thing is just make life easier, for the family. And think about it this way: when someone, passes away, the legal document is not just going to jump off the shelf and, just do everything magically, right? That's not going to be the end result that you're like, okay, I got this document that I don't understand. It's more about, that you've got a plan that works and that everything's in place and there's a process to get your family across that line. And so I'll show you our approach to that today. So that's a trap. I mean, obviously the documents are important, but don't just be driven by that. We want to say, okay, well, how did the documents fit into the overall plan? The other trap I see by people is that they're focused so much on taxes. Believe me, we're going to minimize taxes to the greatest extent possible. I have a lot of background in that side of things. And so, but some people say, hey, I don't have a large estate. I don't need to do estate planning. There's no need for doing the planning. And that is a trap, because taxes are just one issue. And what I mean when people mean that there's no need for planning, estate taxes don't affect many people. If they affect you, that's great. But they affect really just the wealthy, and the estate tax exemption right now, which you have to have on the federal estate tax level before the government comes in. There's an excise tax. It's called the estate tax of 40%. But it only applies, okay, if you have more than $13.6 million worth of assets, right? And that takes a lot of people out. Hopefully you're in that situation. That's good. And we got to do some more planning. But most people, that doesn't cover, okay? And yes, the tax laws are in flux, and that 13 million number is going to change in the future unless Congress does something. Who knows what they're going to do, right? But in 2026, it goes down to 5 million. And so maybe there's an issue there. But again, that's still a lot of money, okay? But estate taxes are just one tax. So I'm trying to show you there's a lot of intricate issues with regard to it. So maybe there's not an estate tax, but maybe you have an income tax issue, right? And the income tax issue when it comes to estate planning, that they keep changing the rules. And it's most of my clients have retirement plans, things like IRAs, 401ks, Roth IRAs, Roth 401ks, TSP plans if you're in the government, 403b plans, right? So there's a lot of different retirement plans out there that are tax sheltered. And when you put a beneficiary designation on those forms, you're doing estate planning. And the government, okay, think about it from the government's perspective. They never got to tax that money if it's in a traditional type of retirement account. They want to get to that tax, and then the best time for them is at the estate side. If you mess things up on that, how you fill out those forms. And there is a new legislation that just came out, Secure Act 2.0, that impacts all retirement plans and all beneficiary designations. And so when you write down that beneficiary designation on a form, think about how much money is in that account, right? And so a lot of my clients, they have a lot of wealth built up. Let's make sure we've done the right thing there and understand all of our options. So that's just one example. That taxes rears its head in different formats. And taxes aren't the only issues we'll go into today. The other is the transfer trap. Hey, I just want to have my family avoid probate after death. And if you don't know what probate is, it's basically a court-supervised audit of your affairs at death, and it's completely avoidable. So think about it from like if you have a financial account. This is the best way I can explain things. I try to explain things with examples, but let's say you have a bank account in your own name and you die, okay? And let's say you're married. It could be single too, doesn't matter. But let's say if you're married, your spouse wants to be able to access that account. They go to the bank with your name on the account. Is the bank going to even talk to them? No. Okay. They have no legal authority to access that. Go get a court order is what they're going to say. So probate is going to be a way to get a court order. And while you're there at the courthouse, guess what? They want to audit everything that you own to the penny. They want an accounting. They want to know everything you die with, date of death. They want valuations. You got to account for every penny. And then you've got to make sure you've notified all the heirs. You got to notify all the creditors. Let everyone have their day in court to fight it out. And after everyone feels like they've had their say, then you can transfer everything out. Completely avoidable. Okay. So that is a big one. And we want to make sure. But if that's the only goal that you have, I'll show you how to do that without even any legal documents. Okay. So you can say, oh, wow, I learned something. I don't even need an estate. I think that it's very risky doing that. And, but I'll show you how we'll do that. Okay. That's a later slide. So what I find what's really missing when people do their estate planning is that they don't really have someone to work with to counsel them on their specific needs and their specific situation, and giving them different options to choose from. Right. So, what I get concerned about when people do planning is that they're looking at it. You can go to LegalZoom if you wanted to, right? And LegalZoom, you're just filling out some biographical data. You they spit out some forms for you. Maybe you got it right. I don't know. All right. And so it's very dangerous. And the forms are just one part of it. The documents are just one part of it. And when I see a lot of the attorneys that are out there just offering, to provide you a trust for a fee without even meeting you, that tells me that they're just basically providing some word process documents for you. They're not getting your specific situation because every client is different. And a lot of estate planning you're going to find is driven by the assets that you own. And so a lot of people don't have, good counseling on this. And so their snapshot might be fuzzy. This is my thing of your snapshot of your plan. Again, the goal is to focus that snapshot for you. So you're like, okay, now I can be a good consumer, understand what my options are, and let me figure out what works best for my family. So let's begin with the basics. One thing that I would ask the attorney if I'm doing estate planning is I would ask how they define estate planning. You should understand the definition of estate planning. This is not in the Black's Law Dictionary or Webster's Dictionary. This is the National Network of Estate Planning's definition, but I like it. It covers all the issues so that you know that you've covered everything. So here it is. Definition of estate planning. I want to control my property while I'm alive and well. Never had a client have a problem with that one. You shouldn't disrupt any of that. a plan for me and my loved ones if I become disabled, mental disability, right? So it's not just death planning, it becomes disability planning too. And then when I get hopefully you never have to deal with that. And then when I have to give, then I want to give what I have to whom I want, when I want, in the way that I want. I'll show you the different ways that you can leave your wealth to your family. And then all while assuring my wisdom is transferred along with the rest of my wealth. So we're trying to set the bar here, at least for us, is yes, we want to make sure your wealth is transferred over there. But if there's things, this is a gift you're making. And so this is the best place if you've got some wisdom there, some life lessons, some values, some stories to pass on. If we see some opportunities there to identify and record and memorialize those, we'll bring that up to you. Okay. Not everyone does the more of the non-material wealth, but it's there, it's available. But the main thing is let's get things to where we go as seamlessly as possible. Our counseling philosophy, this is our approach. Not all attorneys are different, but I like the approach is this planning pyramid approach, where this visual, the purpose of this visual is just to show you, the way we work with clients is we'll work with starting at the base of this pyramid and working with the clients through our process, working up towards the top. And so the first part of our process is just really getting to know what your specific situation is, what are your goals, hopes, fears, and concerns. And then we look at the family. If you're married, what's the spouse's situation, how is their health, what are their goals, and the like. If you have kids, are the kids minor children or are they adult children? Whole host of different issues if you have minor children than adult children. Minor children, we have to think about guardians, who's going to take custody if, God forbid, something happens to us, right? And then a lot of people with my younger clients, they have life insurance policies that get paid, right, on death. And so now you've got a pile of money and the person managing it for the kids have no clue what to use the money for, right? So there's no instructions behind it. So those are some things. And then they're also thinking about like child care powers of attorneys and what happens between the time of death and the probate meeting. In Fairfax County, Virginia, it takes you about 2 months to get a meeting. Where do the kids stay there? Well, we have an appointment of interim guardian form that covers that, right? If you have adult children, or if you have any kids with special needs, there's a lot of issues there, and the trusts really work well. We'll talk about trusts when it comes to that. And then if you have adult children, how is their health? How do they get along with one another? How are they with the finances? Age doesn't necessarily equal experience. Do they have creditor issues? How are their marriages? If they're married, strong, shaky. So once I know the lay of the land, right, then I can show you strategies to preserve wealth, expand wealth, and then save taxes. Obviously, taxes are important, but that's the last piece of the puzzle. Once I know the situation, then it kind of presents itself on that. And so that's our approach to the planning. And basically, to summarize, you teach us the family, we'll teach you the law, and together we'll make the plan work. It's just co-creating the plan. All right. I'm a bullet point person. So the way I bullet point, and I get asked to review people's estate plans all the time. And so here's what the 4 bullet points I would find is if you have a plan of your own, or if you're looking to get one, these are the things that I would find. These are the keys to have an effective plan. Did this person get good personalized counseling? And yes, I spelled counseling with 2 L's. I'm a counselor at law, right, with 2 L's. And so I'm making a point that it's more than just some word processing. We're trying to give you some options and make sure you're picking the best ones given your situation. Again, I'll give you examples. Number 2, proper asset ownership. I would say this is probably one of the biggest pitfalls in estate planning, and is that people have their assets improperly titled. And the basic concept is they have their instructions and their legal documents doing one thing, but the way the assets are titled are another thing. And title really controls. Okay. When it comes to estate planning, think about it. When you go to that, when your heirs or your family go to that bank that's in an individual bank account, what paperwork or how should we have that paperwork set up so that they don't have to go to court, that it's seamless to get it over to them, right? And so there's only 3 ways you can own your assets, right? Your individual name, jointly, and by contract. That's it. Okay. And so a lot of people get confused on the contract stuff. And so, that's why you rely on people that have gone through this. Contracts are things like IRAs, 401ks, business agreements, LLCs, partnership agreements. Trusts are contracts. Payable on death accounts are contracts. So every contract is a different, and so you just need to know how to navigate those. Um, Third is have a formal review process. Let's have an agreement to take a look at this because things change, right? We're in election year. God, it's going to be a mess, right? But and so there's going to be changes to the laws. I know, and they have changed. I've been practicing for over 20 years, and we've had about 4 or 5 different tax legislations since the major ones, right? And we've always had little ones coming across the way. So it just needs to be updated, and not only that, with growth, with regard to your stage in life, where with changes in the family, your financial situation, the laws. And so some type of process there. I'll show you ours. And then a controlled transfer process, right? When you pass away. And so I'll be very blunt, right? If you were to die today, how prepared is your family if something happens to you today? And what that means is, would they have any idea what to do, how to do it, or how to pay for it, right? Typically early on in my career, I would see, and this is typically what happens in traditional kind of approach that's still being done today, is the death occurs, okay, of, one of the parents or one of the family members. The family has no clue what to do. If they can find the will, they get the will, and then they go to the attorney's office, if they even know who the attorney was, and they are in the grieving process, and they're realizing they have no clue what to do, and the attorney is driving the whole process and controls it, right? That's really, I don't think that's a good approach. I think it should be a better approach where you're in charge and you've made the decision, and your family is the ones that can pick their options rather than just figure that out on their own. So and people like on the traditional approach, like, why does it cost so much to do the administration? Because it doesn't, the model doesn't make any sense. All the education for the family is done at death during the grieving process. And there's typically no relationship with the attorney from the time that they executed the documents till death, right? It could be 20 years for someone had to look at it, 20, maybe more, right? And so a lot of things can happen. So you're telling me it's something that a legal document that was done 20 years ago has a chance of actually meeting what you're trying to do at that point? Very risky, right? And very low possibility on that. So that's what I find is, hey, did they get personal counseling? Did they get assets titled properly? It's up to date. They know what to do. We're in good shape, right? And I find most people are not. Here's your options out there in the world, in the estate planning world. This is my opinion on what you have out there. You can do no documents. That's dangerous. I'll show you why. You can do a will and a POA. So in the estate planning world, we live in the world of acronyms. I'm sorry, I'm just trying to get you comfortable with the lingo. Power of attorney, right? POA stands for power of attorney. There's 2 flavors of powers of attorneys that are out there. There is what's called a financial power of attorney. That is a legal document to designate an agent to make decisions for you. And there's 2 subcategories of financial powers of attorneys, go figure. There's one that's called a limited power of attorney, and then there is a durable general power of attorney. What's the difference? All right. The limited power of attorney only takes legal effect once you've been determined to be disabled. And legal effect means you've designated an agent to make financial decisions for you, right? Okay, good. The other one, the durable general power of attorney, is a legal document designating an agent to make financial decisions for you, and it's effective immediately. And they are in effect you. They can do whatever you can do, right? And so it's a very powerful document that's there. And it only serves purpose while you're alive. It's a power of attorney. When you die, it's gone. The will takes over. The will has no legal effect during your lifetime. It takes legal effect at your death. Okay, it has no, the power of attorney is before you. And so that's one strategy that you can improve, that you can do. But the will approach, okay, if the will-based plan, if the will is a centerpiece of the plan, then the family is going to go through probate. Okay, so that means all your assets go through that government probate process that I told you about. It is cheaper up front. You're leaving the family to deal with all that stuff at the end. It's up to you, right? I'm showing you, the options, but the administration expenses are more because you have to deal with the courts and all of that at that time. And the family's trying to figure all that stuff. And usually an attorney is doing that and charging hourly for that. Okay, so that's a will-based plan, a simple will-based plan. Now, for clients with minor children, you're going to need some type of will document. I'll show you the one that I would recommend, because that lays out who your guardians are for your kids. So can't completely avoid probate if you have minor children, because if both parents pass away, then the court's going to want to make sure that the person who is chosen is fit to be the parent, to be the custodian at that time. Okay, so that's a will and a power of attorney. And you have a will with a testamentary trust and power of attorney. So what does that mean? Oh, wait, I forgot about the healthcare powers of attorney. So let me stop. So you have your financial powers of attorneys. Then you have healthcare powers of attorneys. The healthcare power of attorney is a legal document designating someone to make decisions for you on your healthcare decisions only when you cannot communicate to the doctor. If the doctor doesn't feel like you can communicate, they go to the healthcare agent. And the healthcare agent typically will have broad powers, to consent to treatment or not, to do the tests or not, right? And then, yes, one of the decisions, it's not the only decision. One of the decisions is, I call it the pull the plug. Hey, if it gets to the point where you're just being kept alive artificially by machines, how long does that have to go on before your agent is able to say, yeah, let's pull it at that time? That's the powers of attorneys in the will-based approach. Will with a testamentary trust, a last will and testament, stick with me here. Last will and testament, testamentary trust is a trust that's created after death, okay? With court oversight. Why? Why would you do that? You just do accountings to the court. You have to prove that, but people do it. And so it's, to me, I have enough experience with it. Why? I know the court system's there. If I think that there's going to be some type of will contest or people fighting each other, maybe we do that, right? And have a judge arbiter. I don't want those types of clients, honestly. Our office is very quiet. We're just pushing paper back and forth. We're not going to court, right? And so we have our systems in place so that it is seamless on the back end, or as seamless as we can make it on the back end. So that's the will and POA. The simple trust, I see a lot of these. I call them a simple or bare bones trust, where you get out it on LegalZoom or something. It's basically a word process document. You typically don't know what it says, and then there's no little follow up on that. And so that's one of those. I've seen a lot of those. And then the modern approach is, the documents are just part of the deal. It's the process that's important. If someone dies, that when the family calls us, we pick up the phone. Our mission in our firm is very clear, very crystal clear, is when we get that call, we want to be able to say, everything's in good order. Just be with the family. Here are the final arrangements. When you're ready to talk to us, you're going to get priority. We have everything laid out as far as a process to get your family through the administration. Okay. They don't want to hear, I think everything is in good order. I haven't seen you in a while. Documents haven't been updated. Let's go figure it out. Let's try to figure that out together. That's not acceptable on our side. And so that is a process-based approach, and the documents are there just to support it on that side. And I'll show you the documents. The documents that we use typically are going to be a trust. I think trusts are really powerful, and I'll show you what a trust is and all that when we get into the design issues. All right. So here are the challenges that are out there in the estate planning world. So we got the 5 ways to plan, and now the challenges are, the big one is mental disability. I've had some personal experience with that. And the big point or concept there is, to be blunt again, when you die, right, we're not having to take care of the person anymore, right? But if you're disabled, now there's a whole host of other issues, right? Okay, where are we going to take care of you? What type of care? And who's paying for that care? And where that's going to be at, all those issues that are really major issues and really take a lot of time if you haven't planned through them. Oh, that's what I mean by that. Asset transfer on death challenge is, I don't want the bank or the financial institution to say, go get a court order. I want to give them a piece of paper that I've created internally, and they say, yep, everything's in court order, let's go to the next one, right? That's what I mean by asset transfer, and that's being seamless. Taxation, right? Minimize it to the greatest extent possible. Obviously, we'll make sure of that. Okay, that's important. We'll do that. Personal planning goals. Let's make sure that whatever you're trying to achieve in your planning, maybe you have minor children, or maybe I have a daughter who's 8 years old. One of my concerns is something, if I get hit by the bus, is, hey, who's gonna, if she gets some money, how are we going to make sure that those assets are protected for her, that someone is there to help her to get through certain issues? And if she gets into a bad marriage or something like that, those assets are protected. So your personal planning goals, which we'll get into. So those are the challenges that are out there. You got your options, and then you got your challenges. Our approach, again, not the only approach, but I like this approach. It really is the one that resonated with me. Is a 3-step approach. It's an empowered approach. We're empowering your plan. We're empowering your design of your plan, because we're going to develop the plans, not only develop your plans develop your plan with counseling-oriented planning partners, right? And so what I mean by counseling-oriented planning partners is people who are going to sit down with you on your different options. We're obviously going to be one of those. If you have a financial advisor, that's a great person to be a part of that. Not a requirement, but it makes things go a lot smoother, because a lot of the things that we're dealing with are assets. And if we have a human being to deal with rather than an 800 number from T. Rowe Price, we've got a lot better chance of getting things smoothly transitioned. Then we want to empower the legacy by committing yourself and your family to a continuing maintenance and education program. So let's just check the vitals each year. Let us interrupt you a few hours each year to make sure we're on track. And so that when something happens, we can empower that inheritance for the beneficiaries. And that means securing appropriate assistance for you and your family to transfer your wisdom along with the rest of your wealth. When we get that phone call, to get the right people to surround your family to get them through that, right? Rather than try to figure this out over the web or something, right? And so that's our approach. And so let's get back to some traps and get into like some of the technical things. And so I already talked about probate and explain what that was. All right. But let me give you some more facts on probate. And I have a lot of engineer clients. So engineers love formulas. And so think about it this way. Think about anything that you own in your individual name right now. Anything you own in your individual name equals a will equals probate. Okay. And if you don't have a will, you have the government's will, and it ain't good. Okay. It's not a good will. And so that is the starting point. Okay. So how do you avoid probate? So let's go with those different options. So if you did no documents, right, I'll show you how to avoid probate if that's your only goal. You can title everything and joint tenancy. Sometimes it's called joint tenancy with right of survivorship. That is a legal form of ownership. You probably are familiar with that as far as if you have a joint bank account or anything like that. What happens there is when one joint owner dies, by operation of law, the surviving joint owner takes a death certificate to the bank. Boom, the account is outright to the surviving owner. Great, no probate. All right, so let's play this out in a married couple situation. So let's say married couple title all their bank accounts and their financial accounts jointly with right of survivorship and say, we're not doing any documents, right? Let's look at it from the estate perspective on death. And I always have sample characters. My favorite cast of characters is Bill and Mary Sample, and they have 2 kids. And let's say, and I always knock off the husbands first. That's just statistics. Let's say Bill dies, right? And let's say and everything goes to Mary. And so so Bill dies, Mary is the owner, and now everything is in Mary's individual name. And now we're going to saddle or burden Mary, now that we're in the grieving process, go figure out how to distribute everything to the kids without having to go through probate or get it over to them seamlessly. That's not a good strategy, because usually the surviving spouses they have enough issues and tension as it is at that point. But that's the approach that many that you can do. Now, if you say, well, we just go ahead and add the kids to the joint account, think again, okay? Because once you're a joint account owner, you are an owner. So all of your debts and all of your baggage and liability, that's all fair game on those joint accounts. And creditors can get to that, ex-spouses can get to that, those types of things, right? And they are owners. They could just take the money if they wanted to. So not a good way of really getting the plan done. Now, there's something called transfer on death accounts or payable on death accounts. These are the financial institutions forms that say when you die, list of beneficiaries will go out right to them. So again, now you're dealing with the bank's trust documents and look at the fine print and dealing with the banks on that stuff. And then you're going to lose out on a lot of protections that you can provide for your family, which I'll show you. And so it is a tool in the toolbox, and we use it sometimes, but it is not a hammer like one size fits all and do all the planning for that. Okay. But in limited circumstances, we will do things depending on the types of assets and your goals that you have there. And then planning with the box is another way, that avoids probate. What I mean by the box is your IRA is a contract, your 401k is a contract. If you complete that beneficiary designation properly, right, then those will go to the beneficiaries that you listed. But like I told you, there could be a whole bunch of taxes embedded, or you might be exposing the beneficiaries to some liability and the like. So you got to be careful with those. And there's typically a lot of wealth in there. So not a great way to do it, but it is an option if you're just trying to avoid probate. But I talk about what about your goals? Like, does it meet what you're trying to accomplish? You actually, you came here to try to think through the issues for you. Here are some common issues that we see. These aren't all the issues, but these are the common ones that we see for our families. And so they're concerned about, hey, if one person becomes disabled, do we have a plan, or is this going to be a complete mess, right? Remarriage protection, we'll talk about that. Creditor protection, a lot of misunderstanding about creditor protection and trust. I'll explain that to you. Divorce protection and values promotion, okay? So let's take them one at a time. Catastrophic illness protection. So let's say that you did have that big illness towards the end of your life. Let's say stroke, Alzheimer's, and dementia, right? My dad had dementia. And do you have an opinion? Do you have an opinion if you were in that situation, if you'd rather be taken care of at home or in a nursing home, right? Or you don't care? A lot of our clients do have an opinion. They don't want to go into a nursing home. They made specific kind of arrangements, or they want to stay in their own home, right? And so where in your legal documents does it say what your opinion is, right? And a lot of people think that they've handled their disability planning because they have what's called the healthcare power of attorney, or sometimes it's called an advanced medical directive, depending on which jurisdiction that you're in. And like I told you, the medical directive is just a legal document designating an agent to make decisions for you. But it also says where you're going to stay. It's going to say, you can check me into a hospital. You can check me into a nursing home. You can keep me home and bring home care in. You decide, healthcare agent. And if it's that important to you, let's put it in there, right? And so we have checklists and the like that we can get that squared. If you don't care, you're not doing your family any favors, because I went through this. My dad had, and he did care. His attorney never went through it, where when he became disabled, we didn't have an idea how long he wanted to stay at home, because it got to a point where he needed 24-hour care, and it was a huge burden for my mom. But we weren't going to put him in any home because we just had, that feeling, and we never had that discussion. But I suspect if it got to a point where we asked my dad, where we had machines in the house and 24-hour, and it's very expensive. It blew through his whole retirement. My mom had nothing from that, from his assets. And so that is really painful, okay, and really tough for the family. And so, my role, I feel, is I have a job to at least raise the issue and have the conversation about it. And I have checklists to get us through that. Okay. And so, the issues on the disability planning is, would you rather leave instructions for your own care? And then on the other side, a big thing was with my dad is it got to a point where he was sending checks to the wrong people, and people were taking advantage of him from the financial side. Okay. And so that is a big deal, taking away control. And so if you haven't thought through that, it's a very difficult, process. And it could be very expensive if you have to go through the legal system. And so just need to be aware. And our process to deal with that issue is we want to ask three critical questions. If there's an issue of disability, right? We want to talk to our clients now to go through let's think through this issue ahead of time. And these are the three critical questions we ask our clients. It's like, let's figure out when you're disabled as you define it. Let's come up with a good definition of disability. Let's go about who do you trust managing your money if you are disabled next month, not thinking 20 years down the line. And what can they use the money for, right? When, who, what? And we approach this where, yes, you do need a doctor's opinion, but a lot of documents I see out there say when two licensed physicians anywhere in the world say they're disabled, they're disabled. And I don't like that approach. You just don't wake up one day with dementia. So I think there's a timing component, and your family knows you best. And so usually I will make what's called a disability panel, that their only job is to determine if you mentally can manage your financial affairs. They're not making healthcare decisions for you. So yes, I want my doctor there. I want my spouse there, if you have a spouse, or your children if they're ready, or friend, right? So let's make a good panel of the people that we trust. And then who do you trust managing your finances at that point in time? And what can they use the money for? And we go through that. So I think that's the approach. Having processes makes this stuff, because there's a lot of tension, money, family. Strong process gets us through a lot of those shaky areas. Catastrophic illness planning. We don't do a lot of this planning, but I just want to bring it up to you so that you're aware of it. It's dealing with Medicaid, where my dad again had a long-term care issue, had dementia, and it's not covered by your health insurance to pay those bills to keep him at home and to take care of him. And so we were out of pocket. Okay. And it is just astronomical, the amount of the fees that are out there for long-term care. It just depends on which area you are in, but in the Washington metropolitan area, you're looking at anywhere from $6,000 a month, and I've seen it as high as $30,000 a month. I'm sure they could be higher a month for the care. Okay. And then the family's just seeing everything just go out the door. And this catastrophic illness planning is, if you have a modest estate and a family member has this, is there a way where everything doesn't get taken to taken for the care, and then can we protect something for the family? And you can, if you know how to arrange trusts in a certain way and do it. And then Medicaid is the only government payer of those long-term care resources. Medicare is not. It's a difference between Medicaid. For Medicaid is a means-based program, which means you have to show them you're penniless before they will do a dang thing for you. Okay. And so you have to divest yourself of all your assets. So I'm not getting into that. That's just letting you know that that's out there. Remarriage protection is another issue when it comes to estate planning. I don't know why it's a major issue. It's not about trust between the spouses. So let's say Bill and Mary Sample, my favorite cast of characters, and they have two kids, and let's say they have what's called the I love you wills. The I love you wills are the wills that say, if something happens to Bill, when Bill dies, everything goes to Mary. When Mary dies, everything goes to the kids, right? Pretty basic, straightforward. Mary dies, everything goes to Bill, then to the kids. All right, so let's play this out with when it comes to remarriage protection. So let's say I always have Bill knock out first Bill, right? So let's say Bill dies, everything goes to Mary. And let's say Mary's will says everything goes down to the kids, right? But let's say Mary, you know, goes to the tennis club and falls in love with Bo the tennis pro, right? And she falls in love, she gets remarried. And let's say Mary dies before this Bo guy, right? And Mary's will says everything goes to the kids. Does Bo have a legal right to those assets? In all 50 states, he has a legal right to those assets, okay? Depending on which jurisdiction you're in, it could be a third, it could be a half. And so they can say, I don't care what the will said. I'm a spouse. I have rights through statutes, right? Okay, that's one issue. The other issue is a teaching point is that the title really controls or trumps the legal documents, right? What does that mean? So if we had all of our bank accounts, if Mary had all of her bank accounts with Bo titled jointly, the will doesn't do it. The joint bank account, the bank's going to just say, oh, that goes to Bo because he's on the account. Or who's usually the beneficiary of an IRA in a married couple situation, right? It's usually the spouse. And so the spouse IRA custodian says, oh, Bo's the beneficiary. Boom, money goes to Bo. And so my point is, if there was a way that Bill could leave all of his assets to Mary, Mary could use it for whatever she wanted while she was alive. But when she passed away, it had to go down to the kids. Is that something that's worth spending some time talking about? Right. And so I'm trying to highlight the distinction between a counseling oriented approach versus a word processing approach where you give me some names and here's some documents. But let's talk about that. Okay. It may not be a big issue, but let's at least cover the issue, right? Creditor protection is one of the bigger issues. And so let me talk about that one. I have to just grab the door really quick. I'm going to be back 1 second, and I'm going to get into creditor protection because creditor protection is one of those things where you have to make sure that you're clear on all those issues. Okay, so from a creditor protection standpoint, I'll share the screen. And I find there's a lot of myths when it comes to creditor protection and trust and the like. So let me go through, and I have my school bus story to explain what creditor protection looks like. Okay, so let's say in this story, I'll use let's say the Bill and Mary sample again. Okay, and so let's say Bill dies. And then Mary is all distraught after Bill dies. And let's say that maybe she's got the kids in the back. And let's say the weather's not good in the Northern Virginia area today. It's snowing. And let's say she not paying attention, runs a red light, bam, hits a school bus full of kids. Although in Loudoun County, there's no school buses working today. But you get the point. Horrible facts. Let's say one of the kids dies. Mary hates herself. The world's against her. There's not enough money or insurance that's going to pay for hurt and killed school children, right? So these are catastrophic creditors. And so I'm going to show you the different ways that Bill could have left his assets to Mary. Mary could use them and the different impacts of that when it comes to creditors, right? And obviously, this is a horrible situation. Someone said you should use a school bus full of lawyers, right? But the point is it's a catastrophic creditor, and we're just trying to show you how to protect the estate as much as possible, okay? So that don't take everything from us. So let me show you the different impacts. Let's say Bill did a simple will, right? That's that one option. And it said everything goes out right to Mary when I die, right? So everything goes out to Mary. Mary hits the school bus. There's creditors. All those assets that Bill left to Mary, gone, okay? Those are subject to her creditors clearly. The third way, remember that title, so let's title everything jointly, right? Joint with that right of survivorship when everything goes to the surviving spouse. The house, titled jointly, all these other things, right? Titled jointly. Remember I told you it goes outright to the surviving joint tenant by operation of law. All those assets, fair game. They can put the lien on the house. They can take the bank garnishments. All those things titled jointly, fair game. Let's say they left stuff by contract, a life insurance policy, not worth a lot when I'm alive, but let's say it turns into $1 million, or when Bill is alive, it turns into $1 million when he dies. Bill put Mary down on the beneficiary designation form. She receives that $1 million, puts it in her account, hits the school bus, gone. Fourth one is she has created one of these simple trusts that he created one of these simple trusts out there that have very little counseling behind it. And the provisions of the trust, the dispositive provisions of the trust say, hey, everything, pay all that out to my spouse outright when it passed. Same problem, all subject to creditors. So let's go through the different, this last point. So what if we did it, what if we do it another way? Let's say that we pull myself out of the grave and let me do the planning this way. Let's say that I could leave my asset, or Bill could leave his assets to his loved ones. It could be the spouse, it could be anybody, it could be the kids, right? He could leave the assets to them. They can use it for what they want. But if they hit the school bus, right, or if Mary hit the school bus, all those assets are protected from her later creditors. So let me say that one again, right? Bill leaves his assets to Mary. Mary can use it for whatever she wants. But if she hits a school bus, it's protected from her later creditors. So I really want you to connect the dots with that definition of estate planning. So remember that definition of estate planning. I said, I want to give what I have to whom I want, when I want, in the way that I want. So this is one of the ways that you can leave your assets to your loved ones. So my question to you is, how many of you would like to leave your assets to your loved ones that way, protected from their later creditors? And then how many of you have ever been asked that question before, right? And so is that counseling? Is that word processing? How does that work? And so the way, that works is with the trust. The trust is a great device, a great legal device right now under the current laws. It could be changing if they change the laws, but the trust has a lot of flexibility. And a trust is just a contract, okay? And typically, our clients are all, there's three parties to this contract, and they're all three parties initially. They're the trust makers, they're creating it. They're the trustees, they're the one managing it, and then they're the beneficiaries. And you're really just building a succession plan, okay? And from an asset protection standpoint, there's a lot of misinformation out there. Typically, a very sound, our base kind of trust planning is we create what's called a revocable trust. As the name implies, revocable, you can change it, okay? And so from a creditor standpoint, if you can change things, you're not going to get asset protection. You're not getting asset protection from a revocable trust. So when Bill, if he created a trust during his lifetime, he could get in and out of it. But if he had a creditor during his life, they can get to it. But when he passes away, he can put the lid over the trust and say, these are my hard-earned assets for my beneficiaries. They can use it for what they want, but it's not for their creditors. It's not for their ex-spouses. It's not for Medicaid to require a spend down. With their money, you can do what you want. This is my money leaving. Very powerful, very entrenched in the law and under trust law, hundreds of years where you can do that, okay? Very powerful, okay, if you have something to protect. And so, but it's not, a lot of people think, oh, I've got a trust, I've got asset protection. No, not, depends on what type of trust you want. And so I do work with, a lot of high net worth people that say, Bobby, that's great that I can do that for my family. But what about for me? Okay, how do I get asset protection for me? And so we can do that, but that's more advanced planning, okay? That's not something for today. But if you do have those issues, I represent clients, maybe in risky professions that they want to protect their assets. And that's just knowing how trusts work and being able to arrange the affairs that way. But that is advanced, okay? Most plans, just revocable trust. Let's get things in order. Let's avoid the probate process. Let's have a plan for the disability. When we pass away, let's protect it as much as we can for the family. And one of the protections is divorce protection. And so it's really for the kids, right? I call it some of my clients call it bloodline protection. How would you like to assure that the assets that you leave to your beneficiaries actually stays with them? Okay, that's divorce protection. And then values promotion is more of the babysitter story. And so my babysitter story, I told you I have an 8-year-old. And so When she was 4 and we were hiring 3 or 4, we were hiring our first babysitter. If you have any kids or ever had babysitters, so one spouse is asking, or telling all the instructions, hey, she's going to want to stay up late. If you read a story to her, read every page, because if you skip a page, she knows. I don't know how she knew, right? We're going to be here. Here's a neighbor's information. So you get the idea. We have all these hosts of instructions for our kids when they're little, and we're just going away for one evening, right, for a dinner and a show. So my point is simple. How many of you agree that we leave more instructions in that scenario when we're just going away for one evening than we even think about leaving in our estate plans when we're going away for a lifetime, right? And again, I'm not going to give you a blank piece of paper and say, give me your values. If there are opportunities to identify certain things, we'll let you know. It doesn't have to be integrated, but this is something it's a gift, and this is the nicest place to put it in if we can find that. So those are the kind of the how we design the plans with our clients. I look at it like it's going to the trip to the eye doctor. They call this a phoropter, by the way. I figured that out. But it basically, and I can never guess when I'm going there, like, which one do you like better, one or two? But the point of it is we're going to co-create the plan. We're going to narrow the options. That's how we do it. Okay. And I think that's the way to do it on this planning. So that's kind of our step one, to give you a flavor of what we do on step one. Our maintenance plan, I used to go through and focus, focus on the importance of having your plan updated. I think people get that things need to be updated. So I'm going to assume you know that. If not, we can have a separate discussion. But the point of that is I find people just don't want to pay the attorney for that. Okay. Because then you're on hourly. They don't want to get nickel and dime. So to me, I need to have a relationship, and we want to make sure things are in order. And so we're not going to charge hourly. We've taken the meters off the phone. And so we just have a flat fee we charge clients. We charge them $1,250 a year. And what do you get for that, right? Instead of hourly billing and nickel and diming people, you get the following. We are not going to, for phone calls, emails, and faxes, that's part of the deal, right? That is something that's part of the estate. I don't want you to be worried about getting a call in the or a bill in the mail now that you talked to the attorney, or if there was a letter or anything like that. Those issues there off the table. Copies, word processing amendments, someone moves, someone changes a name. That's fine. We'll get that. That'll be all part of the plan. The thing that I think is in itself of the value is the ongoing, and this is important, is the annual funding double check and ongoing funding support. So this is an important concept. I did not come up with the name funding in the estate planning world, but you need to know it. If you are interested in getting a trust, then you need to understand what funding means, because that is one of the biggest pitfalls in estate planning that I see. And so an annual funding double check and ongoing funding support. So what does that mean? The best way to do it is to show you by example. And so every one of our clients every year, they get this asset review report. And the asset review report is an inventory of their assets, okay? So that if they got hit by the bus, I don't have to play Sherlock Holmes to go find everything. I hit a button, I know where everything is at, and we can get those assets transferred over to the right people. We know we're not going through court and the like. That asset report, okay, when we do the initial setup of your plan, what we're doing is we're going to be funding your trust. If we create a trust, we're going to fund it. Funding the trust is actually putting your assets in the trust. Why is that important? So that when you die, the trustee of the trust, the person holding the trust, right, can manage that trust without having to go to court. Everything is there. Again, if things are not in the trust, guess what? The trust doesn't do much. Okay, all those assets have to go through the court, go through probate, and then give you a legal technical definition here. Most plans that are trust-based plans that people get, you're going to have what's called a pour over will. Pour over will sounds nice. I call it the legal pooper scooper. Cleans up after your mess. It says, if I forgot to put something in my trust when I should have during my lifetime, scoop it up and pour it into my trust after my death. Sounds great, right? The good news is it'll eventually get to your trust. The bad news is we're going through probate on every asset that's out of the trust. So there's going to be a probate and an administration with the court. And I haven't gotten to this part yet. We're going to get to it. Then there's a trust administration, okay, to get the assets over to the right people. So you didn't do your family any favors. It actually costs more to do that, because I see partially funded trusts. That is probably one of the biggest pitfalls to estate plans that are out there, that people buy these trusts, is they don't do, the attorneys don't take the time to do the follow-up, the tedious, the time consuming. They leave it to the clients to do that. They give them some instruction letters, and I find it doesn't get done because it's really time consuming. Okay. And you need a PhD in form reading with all these new things, new accounts in financial institution. And then Schwab was bought by TD Ameritrade, or the other way around, and all the account numbers change. All these things have to be all done again. And that is really, the stakes are high, because if you leave stuff out, the trust doesn't work. Okay. And so that is part of the process. Our process is an integrity thing. We're not only going to set the trust up, the legal structure, and typically our legal structure is you're going to get some trusts, you're going to get medical directives, powers of attorney that we talked about. You're going to get a pour of a will just in case, or if you have minor kids, we need the guardians pointed there. And so those are the legal structure. That's a typical one, but that's not it. You have to compare apples to apples. And so the funding, the titling of all the assets is also part of that. Okay. And depending on the number of assets you have, it's going to depend on what we charge and how things go, right? If you have 70 accounts and 5 pieces of real estate in different jurisdictions, we got to talk. Okay, I'm going to go through the fees, generally what we do, but the $1,250 that we have for the maintenance plan at least covers you on the maintenance side of things. And every year you will get this report and you give us the new values, right? A checkbox means we got a piece of paper in the file. It's verified, it's in the trust. Why isn't this Bank of America in the trust? Well, the bank accounts, we can't actually go to the bank for you. We can get you the goal line. We'll say, here, take this to the bank, right? But you got to give us some verification, okay? So these are the things we tell the clients, hey, send us a receipt so we get, or the verification that we can send that. And then also you give us a new value so that we make sure that if we don't have a tax issue or anything along those lines, okay? So the asset review report, valuable tool, really important. And it's a way to keep the funding in check. And then I don't presume that you'll never open up another account ever again, right? And so on that side of things, the idea is if you do open up a new account, you have to tell us beforehand so that we get the account title up front the right way. We'll work with you rather than you do something to mess up the plan and then come to us afterwards and try to clean up, right? Let's just just have a communication and let us know. And so that's ongoing funding support, because really we want the plan to work. We can't. So that's important. The next thing is family meeting. That's no additional charge. It's only within only one family meeting at no additional charge within 6 months of the signing meeting. Certainly can do family meetings down the line, but that would be separate. But I want to, if the key players, to make sure that they know their roles, responsibilities, and the like. Every year we have an annual group client meeting. And we do this at the end of January, which is coming up. I'm writing my outline now. We do about 3 or 4 of these meetings. They're on Zoom. And the annual client meeting, it's in group format. We've got about 80 attendees for the first session. And what I do in that meeting is I go over what's going on with the laws. I've got different conferences, so I get the latest and greatest from what they're going to do on legislation. So I decipher all that for the clients and how that impacts them from an estate planning perspective. I'll go over what's going on with the law firm, team composition, our process, any issues there, and just make sure people are comfortable, with the plan. Every 3 years, we'll actually do group document updates to update your legal documents so they're fresh. And we have a very strong process on that. We've been doing on this process we started this process in 2007. I've been an attorney since 2002, but I found this process through the National Network of Estate Planning, and it's really helped as far as organize and the planning. And so the second report that we use and so what I mean by that is the first few years we're still trying to figure it out. We've got 16 years under our belt. We feel very comfortable, very strong with the process. But this is like an executive summary of your plan that boils everything down, all the key provisions. And then you can just tell us. We don't have to have a big phone call on, these are the changes I want to make. If we need to sit down and talk, that's a separate, that's a counseling issue. But if it's just these things, hey, I want you to change these people, we're going to update that. Okay. That's part of the deal. And that's every 3 years on the clock. And it's just communicating and understanding how to use the reports. I got my instructions set up and those are updated. And I've got my assets in the right place, miles ahead of most plans if you've got that covered. And so group educational programs, we're doing them on different, topics. The one that's the most, I find that's the most attended and most valuable, clients say, I always say is the most valuable. The clients on our clients ask, we have my client advisory board said, hey, make it really easy for them to find it. And it's called Required Training and 911 Info for Beneficiaries and Helpers. And so these are videos that I've done. I do it live every year, but there's certain videos like what's the 911 information if something happens to a client and you're one of the roles. What are the first three things I need to know? Right? You don't need to be an expert, but we don't want you to have to be at the mercy of like, I have no idea what's going on, right? And so the point of that is to educate the family before something happens. And so that's that one. And then while I'm here, one of the other things on our maintenance plan is DocuBank membership. DocuBank membership. What does that mean? And so DocuBank is like having your medical directives in your back pocket. And so, if you're probably not going to be carrying your medical directives, like the documents in your back pocket, if you get into an accident, right? But if something happens to you, you've already done it. If you've already done your medical directives, what we do is we give our clients a little card. I'll show you how the card looks like. And it's, I tell them sandwich it between your driver's license and your health insurance card, because if you go to the hospital, they're going to want to know who you are and if you can pay. And if this card is there, it says my directives are here. You can dial the number on there, or it can be pulled down off of the web very easily. I'm showing you how quickly it can be done, like with under a minute, so that we're not scrambling for that. And it'll notify your emergency contacts. My directives are right there. Okay. And so these other things that are on here are nice little additions that DocuBank does. They're a vendor that we work with on this. My dad was on different types of medication as he got older, and had the disease, right? And so we were trying to figure out like all the dosages. So this is a nice place to have everything in one place. It's not a legal requirement, it's just nice. And the medical snapshot, it's always good to have a family history, doctors, vaccination history, those types of things. So these are the things that are just, they are good resources, and it's more the logistical side of the estate planning. And then digital assets, I won't spend too much time there. The digital assets is, think about all your online accounts, your Amazon account, your photos, all those things, right? How is that going to, do you want your emails to be deleted or transferred? Does the Amazon account get shut down, or or is it all the things or groceries, things all set up where, hey, I don't want to make it a mess for them. Let them transfer it over, right? Or if you have a website or domain, to protect that, right? To make sure that it gets renewed. So that's what I mean by digital assets. There's crypto you also have to deal with as well. Not going to get into all that right now. So those are the maintenance plan, and that's just a flat $1,250 a year. It's optional. Okay, I don't force anybody to go through it, but we have a very high renewal rate. We're like at 99%. All the renewals are due January 31st each year. We upload all the renewal packets in December, and the clients decide whether to renew or not. And then they're all coming in, right now. And so that's the maintenance plan, and just kind of like a summary of the maintenance plan is these are the things that we're doing to just check the vitals in the background. On your end, it's just only, a few hours, but we're doing things in the background to make sure the plan is as strong as it can be. All right, so we've set up the plan, we've maintained it. Now let's get the plan, secure appropriate assistance to transfer your wisdom along with the rest of your wealth. So what is, how do we transfer assets? It's about funding. And I talked to you about funding, the importance of funding. I'm not going to go through that again. But a lot of my clients, I don't know what appropriate assistance looks like to you, but now we're going to talk about fees. Okay. And so the clients want to make sure that the fees, that we control the costs. They want to have full disclosure of the fees, and that's hopefully it gives you true peace of mind rather than you have no idea how these administration fees and all that stuff is going to come up to play. Okay, so there's 3 sets of fees in every estate plan, whether you like it or not. I just know enough on this side. So here's the deal. The cost of setting up the plan, right? Most people get that, and that's where they're focused on, but they're missing kind of the whole picture. The cost of updating, a lot of people don't update or failing to update, right? And then the cost after death. Most people don't even look at that at all. But most of the estate planning fees and expenses are on the back end, okay? So let's go look under the hood on that. Let me show you what's going on. And these are ranges, right? I can't tell you, if these are guidelines by the courts, and these are published schedules and the like. So let me just get you comfortable with how it works. So if you decided to go with a will, remember, will equals probate. And so these are the probate schedules that are out there. And so this is if your family has to go through the probate process, or if you did a trust and it was partially funded or not even funded, this is what the fee schedules are. These are the reasonable. So Virginia, I just use Virginia here. I've got Maryland in here. I think I got some other, but I'm just going to go. Most of the states are the same. I'll show you how they look like. But basically, they say, oh, we're a reasonable compensation state to be a fiduciary. And so what does that mean? It means that they want to make sure that someone's administering these estates, they get paid. Okay. And so here's the deal. While the assets are tied up in probate, if there's any income being generated, like if you have a rental property or anything like that, or income, dividend income, interest income, 5% of those income receipts, that's a reasonable fee while the assets are tied up in probate. Where's the incentive to get the probate done in an efficient manner? And in Fairfax County, it takes 2 months just to get a schedule to get into the office. Okay. Second, okay, now that's the income. What about the principal? So let's say I had $1 million wasn't titled property, it's going through probate. What can they charge on that? On that $1 million, this one's a one-time fee. This one is each accounting period. Okay, so this is a one-time fee, but on the first 400 grand, they can charge 5%. That's 20 grand. Next 4%, next 300,000, 4%, 12 grand, right? And so you get the idea. These percentages are high. People don't realize, they don't see that. Okay, and the back, read the fine print. Yeah, do all attorneys charge this? No, some will charge less, some will charge more. If you charge more, you better give a good reason. The commissioner, in paragraph L here, may increase or decrease the compensation in exceptional circumstances. So exceptional. Factors to be considered are determining compensation include the nature of the assets, the character of the work, so how unorganized is the estate, right? Do you have one of these asset review reports that we're doing, right? So that's the idea. Loudoun County is the same as Maryland. So Maryland says 3.6%, okay? 9% on the first 20 grand, which is equal to $1,800, plus 3.6% of anything over that, all right? And then Florida fees. So why do I have Florida here? So Florida, and I don't presume anybody, you might have assets in Florida or might move to Florida or the like, but the reason why I have Florida in here, I have it in here for 2 teaching points. And so one teaching point, well, back up, would you agree that Florida has a strong, senior lobby? There's a lot of retirees that go to Florida, right? Some people call it God's waiting rooms. Okay, so there's a lot of retirees there, and you better believe Florida is one of the kings of the states of trust planning. Okay, because they got a lot of, and so you just drive into Florida, there's like billboards that say trust planning for you, right? And so Florida has a very strong senior lobby. They get tired of attorneys charging the fees because there's a lot of people passing away in Florida. So, but these are, as you see the caption here, it says trustee attorney fees. I want to make sure I'm sharing the right screen there. And so it says trustee attorney fees. So that means that that's the trust. And so you may be thinking, that's the fees that an attorney can charge to do a trust administration. And you might be thinking, and a lot of people think this, Bobby, you said if I do the trust, I don't have to go through probate. Right. Okay. But death is a major life event. Okay. And so, yes, we don't have to be on the court schedule, but we have to have closure on every one of your assets and be able to get control over those assets to the people that you want. Those financial institutions aren't just going to say, okay, great, you've got to do things, or your family's got to do things, someone's got to do things to get that trust administered. So we're not on the court schedule, which reduces costs and time and expense, but there's still administration to be done. So 2 teaching points. First one is death occurs just by virtue of having a trust, even if it's fully funded, everything's title right, there's still an administration. Okay. Every one of your assets need to be closure, need on them, taxes, any debts, all that stuff's got to be clean before we get it over. Okay. The second teaching point is Florida having such a strong senior lobby. This paragraph 3 right here puts a cap on what an attorney can charge to do a trust administration. Virginia, a lot of jurisdictions don't have this, but this gives you a good idea of what the market rate is. Okay. So an attorney can charge, I'll boil this down. The attorney basically in Florida can charge 75% of what they could have charged on a normal probate. And that's a reasonable fee for the trust administration. Okay. What does that mean? You get 25% discount. And what are Florida's fees? So I gave those to you as well. You should have all these handouts. But Florida's fees are a little bit lower than what we saw before. 100 from 100 grand to 900 grand, 3%. So you get a 25% discount on that. 2.5% between 1 and 3 million. So you get the idea. Probably more than you ever wanted to know on that side. But let me show you how we do it. So our fees, and these are ranges. I can't tell you what I'm going to charge, but you can give me an idea. I can't tell you you're not going to pay anything until I know exactly, what you have, and there's a specific fee quote. So we just started with administration. So if you're on our maintenance plan, we'll agree to do the administration at 1.25% on the size of the net estate. Only if we're hired. We can't lock your family into using us, although a lot of people want us to. And only if you're on our maintenance plan on that time. Okay. And so that's one of our fees. And it's only there if your family wants to utilize that, but you have to be on our maintenance plan. And you just saw 5%, 4%, 3%, right? That's the traditional kind of trend. This one is much lower. Okay. The maintenance, I told you, we charge $1,250 a year. Now, the first year we charge you a little bit more to get you set up, $2,000 to get you set up on our portal, to make sure all the verifications are done on the titling and the like, get you on the DocuBank and you're square, get all the reports ready to go. And then the upfront cost of all of the trust documents and the funding of the trust documents and coordinating all of the assets, we charge 0.5% on the size of your net estate, subject to a minimum fee of $4,000, a maximum fee of $13,500. Where you land on that just depends on your assets, your goals, and the like. And again, I need to see how your assets look like before we can give you a quote. And that's why the personal information form, if you're going to take the next step and explore further, personal information form is we need to know how your assets are currently titled and what you have. So, because I'm going to go through each one of your assets and we're going to make a plan for each one of those assets. The traditional approach is very little counseling and no funding, typically, I find up front, no maintenance, there's no maintenance, no education. And on the death, it's typically a mess. Okay. I'm just showing you the different options. These are our ranges. Once we know your specific situation, we will let you know. And these are for non-taxable estates. Obviously, and non-taxable estates right now, there's not many people that have taxable estates. Good if you do, right? But taxable estates, you need to have more than 13.6 million before, looking at that. Typically, if you have more than 10 million, then we start looking at, do we need to do this? This back end shows you kind of our business model is we're not trying to be like what's called a will mill, where you just try to pump out as many, clients as possible. Our goal this year is to bring in 60 clients, not 600 or 6,000 clients. Right? I say some people they're just cranking out the wills, and I say, so what they're doing is get through you quick as possible, go find the next client. Our approach is more time up front, more detail work, do the funding, maintain the plan so that when something happens, it's going to be seamless. Okay. And so this is our business model. It's basically less clients, better relationships. The maintenance plan is not a profit center for us. Okay. It's been a loss leader. It's getting to be close to break even right now. But we are providing more value on that annually. So think about it. But most attorneys, I have 2 funding coordinators. Their job is to make sure all the assets are titled. Most firms don't have one. Okay. And we're looking at your file each year to make sure we're in good shape. We need your help, but we're managing that process. And then the succession plan for me is very clear. So a lot of clients, engineer clients, will ask me, what if something happens to you, Bobby? Right? I have more clients worried about my health and welfare than I've ever had in my life. And I would not be a good estate planning attorney if I didn't have a succession plan in place, right? So in the packets, there's attorneys. I have a backup attorney. His name is Ed Clay. He teaches with me at the National Network of Estate Planning Attorney. And he's agreed to take over my clients if I get hit by the bus, and I've agreed to take over his. I've got a team in place. The residuals here from the maintenance plan is able to cover the overhead. Ed would stop taking clients on his end, and he would be able to, without major disruption to his firm, come in the way we have things structured in our processes to maintain the plans. Until my internal succession plan is finalized, I've got some younger associates. I think we've got about 3 to 5 years before they will become partners. And so that will be the next stage of our business model, okay? But it's a very attractive model for attorneys because most estate planning attorneys are asking me that are more towards the mature, they want to retire. They're asking me to buy their practices, and I look at their files, and I basically say, you got to pay me to take these messes off of your hands. They have no relationship with the client. Nothing is funded. And so what's going to happen in those cases that when the death occurs, the kids are going to call or someone's going to call. It's going to be a probate. It's going to be a trust administration. It's going to be really expensive, a mess. And that's not the way I want to live my life. Okay. I'm not going to take their problems. I want quiet in the back office. We're just pushing papers. We're getting things. We're making we're following through on our promises. We've had over 50 deaths. And we've had only 3 probates, okay? And those were, I'm not pointing blame, that's just because the clients didn't disclose certain assets. And I can't title something that wasn't disclosed to me, okay? And so these are things that I take that record really seriously. I was really mad that I had to get the probate, but it's there. So that's fees kind of in a nutshell to give you an idea of that. And then I would ask the attorney, if you're interviewing attorneys, okay, this is your fee for the upfront costs. What's the rest of the fees? If I'm dating myself as far as age, I'm a fan of Paul Harvey. He was a radio kind of disc jockey announcer that would always say, what's the rest of the story? And so I would ask the attorney, well, what do you charge for the administration of the trust? And if they say, I can't tell you that, say, well, here's my assets. I die tomorrow. What would you charge me? You're not going to like the answer probably. Or what are you going to charge me to fund the assets in the trust? Okay. And it's usually some type of nickel and dime and hourly type of deal. And so our goal is to not nickel and dime you on the funding. It's the most important thing. But again, I need to see how your assets are. And if you've got those like 20, you've got different accounts and you're not taking our recommendations, we're going to talk. Okay. And so I'm just giving you ranges, but that's a good idea of it. So the costs after death, The traditional planning, right, is those probate schedules, the standard living trust planning, the Florida fee schedules. You get that 25% discount. Our planning process, we've done an audit of our files, 1% to 2% of the entire estate for the life of the whole plan. Okay, it's not just on the administration side of things. So it's up to you. On those, I'm just showing you the kind of the what the value is, and so appropriate assistance, is controlling costs, full disclosure of costs, and hopefully that gives you true peace of mind on that side of things. And the let me go here. Okay, so I'm wrapping up, running underneath the 1:30 time schedule. So the traditional approach versus the modern approach. The traditional approach, you get the basic documents and questions answered. The modern approach is so much more. It's the counseling, it's the titling, maintenance, the updating, the education, making sure that things are in place if we have a surviving spouse situation and the like. So let me check in and how I did on those questions that I posed so that you know how we answered them at least. And then so you can decide for yourself. So here are the questions, right? I would ask the attorney. First one, please tell me about your interest, background, and experience in the planning field. What percentage of your practice is in estate planning? The reason why I'm asking that hopefully is self-evident. You don't want someone who's doing a jack of all trades. Hopefully, if nothing else today, you see this is a specific area of law, right? Just like a doctor, you don't go to a general practitioner to do surgery, right? You should have someone focus on that. It's all your wealth and your family. How do you define estate planning? That's our definition, right? I want to control while I'm healthy, plan for disability, give what I have to whom I want, when I want, in the way that I want, all while assuring my wisdom is transferred along with the rest of my wealth. What's your counseling philosophy? Ours is that planning pyramid, right? Get to know the lay of the land first, the family goals, situation, then present strategies. What's your process for working with me? I did not show you our process chart. I find process produces predictable results. And so you're here. If you're interested in exploring further, the next meeting would be a discovery dialogue meeting with one of our paralegals. Typically it would be Taylor. She'll go through your personal information form, make sure you've done that right. She's going to go through a goal setting exercise with you. She'll give you some tighter fee range based off of what you show us. And so you get an idea of it. The next meeting is the initial interview. That's with me. There's no charge for the discovery dialogue. That's usually an hour to an hour and a half, just depending on questions and the like. The initial interview is with me. It's usually an hour to an hour and a half. I go through specific engagement agreements, make sure that specific fee quote, go through our process, our maintenance plan, answer any questions on the scope of the work. If everything looks good there, then if we engage, then half of the design fee is due at the design meeting. That's where we go through that trip to the eye doctor, go through all your options on the instructions. That's typically with me. And then there's a delivery and review meeting. That's typically one of our other associate attorneys, Wendy, typically, where she'll review the legal documents with you, make sure you understand them, answer any questions that you have, sign, witness, formalize the legal documents. But we're not done, okay? At that time, then the next meeting is a financial strategy meeting. And typically if you have a financial advisor, that's a great one for them to be at. And this is where we're making sure, number one, we have an accurate inventory of your assets, that asset review report. And I'm going to make recommendations on how to title them. We'll talk about it, make sure everyone's comfortable, everyone signs off. Then the funding meeting is where our funding coordinators, either Ginny or Taylor, will have all the magic forms gathered together for you to get all the assets titled properly, right? We'll submit what we can. Things for the bank we'll get you to. And then we have an optional family meeting, no additional, my PDF is messing up. No additional charge as long as it's done within 6 months of the signing meeting. I'll go over the plan as high level or as detailed as you want with whoever you want. And then you're just on maintenance. There's a heavy lifting. Some logistical questions on our process. How long, Bobby, does it take to get my documents in my hands? If you're motivated, 6 to 8 weeks. The process, we usually do the meetings about 2 weeks at a clip. The funding takes a little bit longer, but you got the legal documents in place, but things come back from the court, trickle in, or verifications come in. But that's how that goes with the timing. And most of the meetings we're doing these days through Zoom. Typically the delivery meeting, we're going to need to have, you come in or have some type of signing appropriate for that. So that's our process in a nutshell. And then how you counsel with me to design my plan. That's, the kind of, I go through visuals, stories. That's how I do it. This is the big one. How do we assure my assets are controlled by my instructions contained in my planning documents? Who's responsible for this coordination? You or me? And so we manage that process, as you see. How do we assure my plan stays current with changes in the law? That's our maintenance plan. What's the level of involvement of my family in the planning process? I believe more involvement is better, but every family is different, so we have to just take what we've got. How do you charge for services? I went through it ad nauseum. Hopefully you got that. What is your record with regard to probate? What am I? 48-3. What percentage of your trust-based plans wind up having to be probated? Do you charge differently for these assets? So if they're going through a lot of probates, that should be a red flag for you, right? That the plans are not working. Now that to me is when a plan doesn't work. Do you handle the filing of the death tax returns if they're necessary? Yes, that's part of our deal. And the death tax returns are becoming more necessary even if you don't have a taxable estate. I didn't dig into this issue, but there's something called portability that is a way to preserve an exemption for a surviving spouse that we're doing for non-taxable estates. So the goal for us is that we want the plan to work, right? What happens if something happens to you, the attorney, right? That's my succession plan. How do I prepare for our consultation? Then just fill out the personal information form, okay? What type of service complete it? What type of services should I expect from you? I'm a believer on team. We've got a great, solid team. And so you're going to work with everyone on the team. And rather than be bottlenecked with one person and things, because Ginny and Taylor are great with the funding. Wendy's great, with the drafting. Michelle's the scheduling. And so everyone's got different, sides of things. Do you expect any commitments from me? Just respect our time, our process, and the like. These are things you should be thinking about. Will obviously help you there. So based off of what I talked about today, think about what issues more resonate with you. The helper roles are your backups. Don't think 20 years down the line because we have a maintenance plan, all right? You just think, if something happening next month, who do I trust managing my finances? And then on the medical side, we didn't get into too much of this, but the healthcare agent has different qualities. You want someone to be a patient advocate to you who's going to follow your wishes and who's going to ask the doctor the tough questions. You have a current inventory of your assets. Big part of it is on that side. All right. So very good. Thank you everyone for your time. This has been Bobby Fazy, president of InSight Law. I'll hang on for a minute or so. I did not see any questions or anything in there. If you do have questions, feel free to ask them, or if you think of them later, not an issue. Be happy to answer anything that you may have with regard to it. But with that being said, I hope you got some good information today. This has been Bobby Fazy, president of InSight Law. We've been talking about estate planning today. Thank you. You're welcome. Very good. Thank you, guys. Have a great day.